Hello everyone, my name is Satyam Shivaach and I am working as a legal intern with LEXIS and Company. And in this video, we will discuss about patent. A patent is an exclusive right granted by the government to the inventor to exclude other to use, make, sell any invention in a specific period of time. A patent is also available for improvement in their previous invention. The main motto is to enact patent law is to encourage inventor to contribute more in their field by awarding them exclusive right for their invention. In modern terms, the patent is usually referred to as the right granted to an inventor for an invention of any new, useful or non-obvious purpose, machine, article of manufacture or composition of matter. The word patent is referred from the Latin term patre, which means to lay open, that means to make available for public inspection. There are three basic tests for any invention to be patentable. First is the invention. The invention must be novel, meaning thereby the invention must not be in existence already. Second is the invention must be non-obvious, that is, the invention must be in significant improvement and the previous one mere changes in technology will not give the right of the patent to the inventor. And the thirdly is the invention must be useful in a bona fide manner, meaning thereby that the invention must not be solely used in any illegal work or in useful for the word in bona fide manner. An invention is considered as new if on the date of filing the application any such invention is not known to the public in any of the form, that is in oral, written or any other form. Anything shall not be termed as inventive if such a thing is already known to a public domain. The patent has a limit term of 20 years, which is counted from the date of filing of the patent application. A patent is a territorial right. Thus it can only be applied to a country where it has been granted. A patent is a territorial right, thus it can only be applied to the country where it is granted. Therefore, any legal action against infringement or infringement of patent right can only be taken in that particular country. And to obtain such protection in different countries, each country must apply for a patent. The Patent Cooperation Treaty provides a way to file an international patent applicable in which a patent can be filed through a single patent application in a large number of countries. However, the Patent Cooperation Treaty of a patent remains discretionary of the individual patent office only after the application is being filed. Under the Indian patent law, a patent can be obtained only for an invention which is new and useful. The invention must relate to the machine, article and substance produced by the manufacturer or the process of manufacturing an article. A patent may also be obtained for innovation of an article or of a process of manufacture. In respect of medicine or drug and certain class of chemicals, no patent is granted for the substance itself, even if it is new. But the process of manufacturing and substance is patentable. The application for the patent must be true and the first inventor of the person who has derived the title from it, the right to apply for the patent being assassinable. Now some of the invention cannot be patented. In the European Patent Convention law, there is a list of non-patentable subject matter, which are include method of medical treatment or diagnosis, and new plants and or animal varieties. Further information on such a field can be obtained from the patent attorney. Not many of the patents been granted to the invention whose exploitation would be contrary to the public order or morality. The following are not being regarded as invention, discoveries or innovation or any of the scientific theories in mathematical method or any aesthetic creation or the state of an artwork or writing schemes, rules or method of performing a mental act or playing games or doing any business presentation or information or any other computer software. Now let's see what are the rights and obligations of the patentee. Starting with the right of patentee, the right to exploit patent. A patentee has a exclusive right to make, use, exercise, sell or distribute the patent article or substance in India, or to use any of the exercise, the method or process if the patent is for a person. This right can be exercised either by the patentee himself or by his agent or licensee. The patent exercise are exercisable only during the term of the patent. Then the next is the right to grant license. A patentee has a right at his discretion to transfer the right of the grant a license or to enter into some of the other arrangement for a consideration. A license is of an assessment, must be in writing and registered with the controller of patent for it to be legitimate and valid. The document assigning a patent is not admitted as evidence of title of any person to a patent unless it has been registered, and this is applicable to assignee and not to the assigner. Then the next is right to surrender. A patentee has a right to surrender his patent, but before accepting the offer of surrender, a notice of surrender is to be given to a person whose name is entered into the register as having the interest in the patent and their objections, if any. The application for surrender is also published in the official gazette to enable the interest of person to oppose it. Then there is a right to sue for infringement. A patentee has a right to institute proceeding for infringement of the patent in a district court having a jurisdiction to try the suit. Now let's start with obligation of a patentee. A government use of patent. A patented invention may be used or even acquired by the government for its use only. It is to be understood that the government may also restrict or prohibit the use of the patent under specific circumstances. In a case of a patent is respect to any medical or drug, it may be important to the government for it to use for any of the distribution in any of the dispensary, hospital or any other medical institution which has been run on the behalf of the government. The aforesaid use can be made without the consent of the patentee or payment of the royalties. Apart from this, the government may also sell the article manufactured by patent process on royalties or may also require a patent on paying suitable compensation. Then the next is compulsory license. If the patent is not worked satisfactorily to meet the reasonable requirement of a public at a reasonable price, the comptroller may grant compulsory license to any of the applicant to work the patent. A compulsory license is a provision under the Indian Patent Act which grants power to the government to mandate a generic drug maker to manufacture inexpensive material in public interest. Even as a patent, the product is valid, the compulsory licenses may also be obtained in respect or related to the patent, where one patent cannot be worked without using the relevant patent. Now the next is revocation of patent. A patent may be revoked in a class where there has been no work or unsatisfactory result to the demand of the public in respect to the patent invention. Then the invention of defense purposes. Such patent may be subject to certain secrecy provisions, that is, publication on the invention may be restricted or prohibited by direction of controller. Upon continuance of such order or prohibition of publication or communication of any of the patent invention, the application is debarred from using it, and the central government might use it on the payment of royalties to the applicant. And the last is to restore patent. Once lapsed, a patent may be restored, provided that few limitations are being imposed on the right of the patentee. When the infringement was made between the period of the date of infringement and the date of the advertisement of the application for reinstatement, the patent has no authority to take action for the infringement. That is all for today's video. Thank you for watching. Please like, share and subscribe.